All right, just some quick housekeeping. The last video I meant to say the Act of Settlement 1700 and 1701. I think I misspoke and I said 1707, which is the act that we're going to go into right now, or the year of the act that we are going to entertain right now, which is the Cestui Que Vie Act of 1707. Now, I'm going to first read a capture that I had taken from a letter that I had received from a third party. This letterhead was from the DCA, which is the Department of Constitutional Affairs in London, which is an institution that belongs to the UK government, and its MO states for justice, for rights, and democracy. It reads that the Cestui Que Vie Act enables a claimant, and we're speaking about the one of 1707, so enables a claimant entitled to the remainder or reversion of an estate to realize his interest where the person entitled to the life interest, the Cestui Que Vie, has died and their death has been concealed. The claimant may make an affidavit once a year to move the Lord Chancellor, Keeper, or Commissioners for the custody of the Great Seal of Great Britain to order the Cestui Que Vie or Cestui Que Vie to be produced, show that they are still alive and therefore entitled, unquote. The above paragraph is captured, as I already mentioned, from the copy of the letter, and there isn't going to be further down another part that I'm going to extract to give validation to the fact that the Cestui Que Vie Act of 1707 is still in effect. Now, it succinctly outlines the purpose of the 1707 Act, which serves as a remedy that was long overdue in relation to people assuming an interest when the estate itself had ended, according to the original agreement, which was that when the person who holds that agreement died, then those in remainder or reversion will now be with right of possession of that estate. Now, for instance, let's say why a person may conceal the death. Let's say a man marries and his new wife comes to the marriage seized with an estate to which the husband gains certain entitlements of use or rent or profits of the said estate according to the marriage contract or marriage agreement, if you will. The husband receives a proportionate control or over this interest in which he can dispose of certain interest that he then becomes entitled to through the marriage agreement. If the wife predeceases him, the husband, perhaps subject to them both having an issue, a child in common vernacular, this affects particular rules in common law, which may serve to reduce the estate of the husband. And this also applies if they did not have an issue, which would also serve to create another common law rule. And that issue being with the right of having the inheritance that was from the mother's estate. Now, so it may serve in the husband's best interest to withhold information of his wife's death, so as to maintain certain control over his former wife's estate. Now, once reported that the wife is dead, then the operation of law takes over so as to satisfy that an event has in fact taken place in which then affects the power in another person who either has remainder interest, that who is subject to a life or fetal estate, or may affect the power of a reversionary interest, the one entitled to the lesser estate after she is dead, who then holds the superior title as grantor, so it reverts that smaller or lesser estate reverts back to him. The Cestui Que Vie Act 1707 then served as a remedy to have the estate interest investigated upon the request of a person in remainder or reversion who will suffer from not being able to control the now defunct estate for their own purpose. So construed as a loss in relation to the use or rents or profits from this estate, which remains to them still as a mere future right of possession. So in a sense, no possession or control at all until that estate is made determined through the death. Now, not to mention that the husband may also cause damage upon the land, such as create more waste or leave the property in disrepair so as to extract more profit in contrast to paying for the maintenance. For our studies, we are never concerned with the future interest called remainder, as that represents a future interest created in some other than the grantor, and it's done through an act of parties. We are always the initial grantor over all land interest, not its beneficiary, and definitely not the remainder men. We will from here on in look to our main interest held in common law through the act of reversion only, whereby the death of the cestui, we have returned the right of this beneficial interest held limited through a life estate. This is our whole plan after all, to vest the legal title after the termination of the life estate in the common law through the death of the beneficiary, whom had received the equitable reward through its use, which was separated via having the legal title remain as the res held in trust and controlled, of course, by trustees. Now, to identify a trust, besides satisfying the three certainties, as you may well know, is namely that three certainties mean that of intent, subject, and object, is to recognize that the legal title is held by a trustee and the beneficial title held by another. This alone identifies a trust because it constitutes, it is evidence of the constitution of a trust. The trust is constituted by notice that the actions of the trustees are through this notice that the actions of the trustee are not passive but are active in relation to the proceeds, the accounting namely of the said estate, and so the trustee is not responsible for the general upkeep of the estate itself, as this would, or I have read, leave the grantor as merely a subsequent annuitant. So, by having the trustee control only the proceeds extracted from that interest associated with legal title, and not being responsible for the general upkeep of the property, this then creates that division necessary for the grantor or the beneficiary to have possessory rights in control of that property as necessary. Or if you just give the trustees, as we're moving to the fourth level of a trust, as I've mentioned in previous videos, then the trustees have all the control and we, without possession, have no voice. Okay? If we remember from past videos that the common law interests lie in grant, coupled with livery of scion, so is a physical act. Grant, as it relates to the conveyance of a freehold, essentially means to transfer the legal rights associated with the land. The statute of uses assisted with removing this necessary ceremonial exercise of act of livery of scion, when it established notice of the original use through a new common law title so as to be recognized in English common law courts and to be immediately under the right of the king again so he can have its incidents and worships and marriage and such, which he holds in common law interest only. The transfer can now be done by deed, by transferring the legal title in the Statute Que use, thereby removing the fiat from the duty, from his active association with the proceeds of that use. Then his transfer gave effect to a new legal conveyance in right of the tenant as a statutory legal power. This allowed for the first common law time for a tenant for life to control a legal interest in land for sale or lease as essentially as an owner, not before available to him before the statute of uses. Okay? And this, through trust rules, could next establish an equitable interest in land, or he could sell his estate as per the requirements of the settlement. Additionally, since both remainder and reversion are future interest, before not recognized in common law, as we have already alluded to, that possession only dealt with the now interest, the physical transfer of that land, not done by paper. Okay, A deed was created to establish this new common law legal interest, so as allow for a future interest to exist. The legal title is merely the rules which allow for a tenure to be recognized. It is not the physical document itself, since it is witness of a physical action of substance, such as a conveyance representing the land through a rock or a twig or a staff. Again, we spoke to that matter. The legal title is essentially the rules that give power to the right in a land interest. And as for the right to a state to create a future interest, then a document was created, termed a title deed, that outlined the conditions precedent, according to the acceptance of the conveyance, consisting of a lesser estate carved out from the original legal title, which became known as the use. That's how we got the idea of a use, that the common law held the immediate title that was subject to the rules governed under the king's court. The use was that through the corporations and so forth, creating a beneficial interest from them, so they only have the rights to the fruits of the land, but not the common law interest in the land itself. That's how they circumvented the incidents and worships and marriages, okay, that were owed to the king through the allegiance or through the acceptance of the personal acceptance of the tenure. And we already went through the four different estates that were created through the purchase of William, which is just William the Purchaser, William the Conqueror. Okay, here's another way of looking at it. Why the maxim of law states there is no heir to living. Okay, meaning the estate, according to the common law rules of inheritance, existed only in the now through physical transfer, and thus the estate may or may not have vested in the heir, so could not be regarded as existing in the moment, because it only came to be when a subsequent estate terminated, most often through the death of a tenant. Now the heir was made apparent and right to the estate, because now that heir was responsible for the settlement of those incidents and encumbrances that may be made through jewelry and through other borrowing money, through the marriages and worships that we owed, for the right of the tenure itself. And this is what I mean when I assist to inculcate into our minds about knowing what is subject matter, so as to bring in the appropriate law based on knowing one's status. Okay? The judge can only provide the remedy according to the subject matter. And as we have all witnessed, the estate held as an equitable benefit is subject to reversion, and the ending of this equitable estate interest, a life estate predominantly, excites a different land interest altogether from the laws of inheritance. So we have an inheritance, different subject matter, to which then we create life estates through it, and fee tails or entails within them, which are limitations, to which then create fee simples, and are subject initially, those life estates, to remainder and reversion. And again, we're only want to focus on reversion. We don't need to speak to anything active parties. Everything that's done is through operation of law and is perfected. Now, back to that letter again from the DCA. It confirmed that, however, this is the quote, however, the 1707 Act stands, albeit having been amended by the Statute of Law Reversion Act 1888, and so cannot be said obsolete, unquote. Like the statute uses, 1707 Act is still in effect. It is important to be reminded also, and is found in the Canada's Interpretation Act, on the subject of repeals. I think it's 44H or 44 section, don't quote me on that, could be 46, but anyways, that whereby any act so repealed must be according to the same subject matter. And if an act not so repealed stands as in effect today. Doesn't matter how far we go back. Even I'm reading Bora Laskin's cases and notes on land laws, and it continually goes back and reflects to the Clea Emptoris statute of 1290. Okay? So if what I mean is, if your remedy to what we want to deal with is not found within the acts that are prevalent within society, then those acts automatically are void. We have to go to a pre-existing act in order to find that remedy. So every act is in effect to the measurement of the remedy needed in order for the court to act in that best interest. It has to go back as far to reach that remedy. But if you accept a remedy or be caught in a jurisdiction and they put you into constructive trust and equity, well, that's the only remedies you're going to be within that cesspool of arbitrary judgments. Okay, you're going to get that, but we have to go pre-existing. We have to begin with where we want to affect our rights to vest that interest, which is a legal interest that created at birth. Has to be created at birth, or we can't deal with English law. Okay? You can find remedy in equity, of course, there is, but my action is to vest the legal estate not subject to a trust. Thereby, I have to bring in the appropriate law so that the judge can effect the proper determination according to my request for the settlement. My individual interest, as is guaranteed in each individual equally, according to the formulas and the time stamp when the estate was created, namely, notice of birth, is in common law and why it is not held by Parliament, but rather in the monarchy, because it's a common law interest, has nothing to do with Parliament. Okay, Parliament and government is a creation of the monarchy, and in the syllogism, that which is created cannot be greater than that. How does it go? That which has been created cannot be greater than the creator. Okay. Now, the monarchy, as I continue, who holds this right to land, not as a tenant themselves, but as fideicommissium, so as to be the keeper of the law, to which can do no wrong, as this title is predominantly representing the entirety of the settled land in each of us, so that land can be used for the benefit of all. It's involuntary, it's for our best interest. Through the event, all land passes through. That's the registration of live birth. That's that interest can be passed through unimpeded, so it can be used by society and also be made available as an inheritance when we are full age to act, which then the law recognizes as is a tenant for life. That then gives us the powers and duties to effect a certain status that we can use when we choose to use it, when we no longer abstain from exercising our rights. And no longer exercising our rights is established in Section 106 of the Settled Land Act 1925, which is our warranty. We will get to that later on. But that is that warranty that ensures two things. When you no longer abstain from exercising your rights, then obviously that's when the subsequent titles and interests are determined. And secondarily, if anyone, once you begin to exercise that right, and this is a beautiful point, shall be void. That means all other means in which someone might try to overreach that interest, it's void. Okay? So as soon as they speak, what? Hello? Exactly. You can't hear them. Just like when you go into court and you start, I'm a man, and I got a common law, and I got my right to property. Just commingle three interests in that one sentence, and like I said, throws you into a constructive trust tailspin, to which now you are now caught within which you didn't want to be caught with in the first place, because you wanted to deal with initially your dominion right, which is separated from the common law legal interest that is held in monarchy, which is also separated from the equitable interest that have been granted the right of government to administrate over the waste during the use of that land that has been used while you go from infancy until you are a tenant for life recognized in law of full age. All right, I think I finished it. I don't think we need to speak to the Cestui Que Act of 1707. We know that it's our warranty, not our warranty. Sorry, it's our remedy. It already right there. It determines that on the death of the beneficiary, through an affidavit, you can go and say, "Hey, I need proof of the death of that beneficiary" to the court, and the court has to then seek remedy to prove that that life estate interest is completed because the beneficiary, now here, get what I'm going to say here, through natural death, which would be you, or through civil death. Civil death is also the death of the beneficiary. We can even look at when a monk or when a person wants to be a monk, they are civilly dead in law. Same thing. Okay, you don't have rights to common law anymore. Okay, so the next one, I would assume, I might just quickly just brush over the Statute of Enrolments, Statute of Wills, and the abolition of the tenures, but just only in a very broad stroke. And then we'll go into the 1688 Bill of Rights and the Act of Settlements of 1700 and 1701. Thank you for listening. Like, subscribe, share. If you find this content of any value, please get this information out, because we, as I've always maintained, are doing it to ourselves.